Hello, this is Matt on the Moon Lambo channel, and XRP holders must take action. They must intervene in this case of the SEC versus Ripple. Yesterday, I put out a video on this topic, actually, and you can see here's a headline from Crypto News Flash covering the same thing. SEC versus Ripple. Attorney Deaton files for intervention by XRP holders as third-party defendants, and I have a lot of updates to share with you in this video, this latest Moon Lambo hot jam. It's going to be coming from 3 lawyers, actually. I'll be starting with John Deaton, who filed this intervention the other day. He had a lot to say, as well as opinions from attorney Jeremy Hogan, and so by the way, both of them are pretty well on the same page as far as the importance of this and just the idea that it's going to have some level of success. But I like sharing perspectives on from multiple angles anywhere I can find such perspectives. And in this case, I actually did. There's an attorney here named Kevin Homiak. I'm not sure if I'm saying the last name correct, but that looks about right. I'm not sure. Homiak? But he shared his honest opinion, and he actually doesn't think that this is really going to go well, frankly. So I'm going to share with you all the information that I have. I love diversity of thought. I think that it's really productive, and I do get the sense that this individual, even though he doesn't think this is necessarily going to be good for Ripple or XRP holders or John Deaton who filed it, I do get the sense that he's just sharing his honest opinion here, and so that's perfectly fine. I think it's silly to get mad at somebody because he doesn't deliver happy news that we would prefer. So there we go. But I do want to be clear that I don't have a legal background of any kind. I am not offering legal advice. I also don't have a financial background of any kind. I am not offering financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who likes making YouTube videos about Ripple and XRP and crypto related topics and stories. There's nothing special about me. It's just a fun hobby. Just want to be transparent. I very much appreciate the support, though. And so let's start by going through John Deaton's comments. And again, he is the attorney that filed this. And so just the idea that you could have John Deaton officially in the SEC versus Ripple case, I personally really like that. That would be absolutely fantastic. On a scale of 1 to 10, I would rate that 2 thumbs up for sure. And so he wrote the following. Why do we fight? I'm sure dozens of critics and legal experts will comment on our motion to intervene and in the SEC versus Ripple and try to tear it down. The writ of mandamus was always a long shot and could even be legally described as a Hail Mary. That's not news. Does that mean we don't fight and try to win? Do we say to ourselves, the game's over, I give up? Or do we say, I won't quit until this game is over and throw the Hail Mary? Life and people will beat you down if you allow it. Trust me, I've been knocked down hard by life, but there's only one option. Get up and fight. I've always said that if you put me in a ring with Mike Tyson, 3 things will definitely happen. Number 1, I will step forward. Number 2, I will get knocked the F out. And 3, if I wake up on wobbly legs, I will try to step forward again. I like that. SEC completely violated its mission to individual investors. The critics can say all they want about Chris Larson and Brad Garlinghouse. I don't care. I live in the United States, and after 7 years of active duty, I was medically retired from the USMC, United States Marine Corps, due to a severe back injury. The SEC is my government, and it represents me, and what it has done, and the way its leaders have acted are morally, ethically, and, in my opinion, legally negligent. I believe its actions should not go unchallenged, and whether the executives at Ripple did or didn't do anything wrong changes nothing related to the SEC's conduct. So when I filed the writ, I was very aware that our chances of having a judge order the SEC's chairman to amend the complaint to exclude today's XRP owned by holders with no connection to Ripple were very low. I'm aware of a little thing called separation of powers between the judiciary and the executive branches. I'm also aware that how to charge a company in an enforcement action is a discretionary act. As I wrote in our motion to intervene, when I filed the writ, I was hoping the SEC would see the damage it had done and come out and provide the market with clarity. Hester Peirce can go on a YouTube channel and say that the SEC is only claiming that the way Ripple sells XRP is the issue, then amend the complaint so it's not so vague and overbroad, or provide clarity so that the exchanges are not worried about being sued by the SEC instead of publishing risk alerts that make it even more concerning for the market participants. I filed the writ hoping the SEC would have the moral courage and leadership to acknowledge its misdoing. The legal experts can continue to say that the writ was easily dismantled by the SEC and that we will lose in the SDNY as well, which is Southern District, New York. The writ accomplished exactly what it was designed for. Not legally designed for, but strategically utilized for. And by the way, actually, if I can just pause there, and we're going to get to Jeremy Hogan's comments in just a moment. I got some things to say about that too. It was really enlightening. But he said the same thing here. He said, forget from a legal perspective effectively, and I'll share with you the specifics, but he said, forget from a legal perspective effectively. This was strategic in making the SEC acknowledge and say things that they otherwise wouldn't, that, again, provide a strategic benefit for John Deaton's legal position. It's awesome. So even though it was never likely that this thing was gonna go through. Okay, so what? John Deaton has been public about. He's been very transparent about that. Actually, it doesn't mean it wasn't worth doing. Of course, it was worth doing. And that John Deaton continues now. It demonstrated the hypocrisy of the government's claims. It also demonstrated that the SEC is enraging in regulation by enforcement and is itself confused as to how digital assets fit into our current regulatory framework. The, quote, legal experts see the writ as a tree being cut down, but fail to realize that that tree isn't the issue. The issue is the forest in which that tree is rooted. The experts and critics will claim that I'm wasting my time and I'm simply spinning my wheels, going nowhere with the motion to intervene. They will say the same thing when a class action is filed. And in the end, maybe they will be correct and we lose this motion, and maybe later a class action is also dismissed on technical and legal grounds. If so, the critics and legal experts will get to tweet, "I told you so." Maybe they will go on a podcast and pat each other in the back, self-gratulate and gloat at their legal acumen or at how XRP investors got duped by the guys from Ripple. But if you read the memorandum of law in support of the motion to intervene or the writ of mandamus, you will have to agree that the way the SEC has handled XRP specifically, and digital assets in general, is inexcusable. If you are objective, you will come to that conclusion even if you despise Ripple or its executives or believe XRP is an S-word coin. And if you come to that conclusion, then I ask you, what do we do about it? Just accept it? If decisions were made at the SEC by leaders no longer there for personal reasons and not based on legitimate concerns for individual investors, do we do nothing? Do we say, that's the system we have? I didn't literally give up my back serving my country to just accept a morally bankrupt system. We may lose. I may get knocked out, legally speaking, as if I was in that ring with Iron Mike. If so, I'll get back up and ask, when's the next round? In the meantime, what are you doing? Well done. Awesome stuff here. I love the vigor with which he does it. Like, you can tell he's got some serious fight in him, and so even if all this falls through, holy hell, why would we not applaud him? And sure, there are going to be some people that are Ripple and XRP haters where if all this stuff falls through, yeah, he's right. They're going to go on podcasts and they're going to be tweeting, and it's going to frankly make them look like unsophisticated individuals. It's going to make them look like jerks, frankly. So let them show their true colors if that's what they want to do. If they want to gloat about how XRP investors got screwed, if that even happens, fine, let them do it. That just says more about their character. But the fact that John Deaton is fighting here means the world to me, as well as the rest of the XRP community. I think it's fair to say that. Now, a shout out to Jeremy Hogan, attorney Jeremy Hogan with the YouTube channel Legal Briefs. If you've not yet subscribed to his channel, what is your malfunction? Like, seriously. I encourage you, if you've not yet done it, if you've somehow missed him, if you haven't checked it out, definitely Subscribe to his channel, Legal Briefs. Just type it in the YouTube search bar. You shall find it immediately. And I want to share with you some of the stuff that he had to say on this exact topic, okay? And I actually did take some notes for this because I didn't want to miss anything. But, it was interesting. One of the first things that that Jeremy Hogan said on this topic was that John Deaton's filing here to intervene is the most important pleading in the case to date, which I found fascinating. I was like, oh, that is rather intriguing, actually. And so he said, the writ of mandamus forced the SEC to argue things they otherwise would not have. And Jeremy highlighted this passage from a recent Forbes article that I highlighted a couple days or so ago. He actually brought up the same thing. And so this article from Forbes, I'm not going to run through it. I'm just going to read just a few sentences from it. That's it, just to make sure that everybody's got understanding of what we're talking about here. But this was titled, SEC Stumbles in Ripple Case, Lost in a Maze of Its Own Making. And I like this little labyrinth picture they've got going on here. That's very snazzy. And they went on to cite what attorney John Deaton has been doing here. And so check out this. I'm just wondering, it's just a few sentences here. Jeremy Hogan on his channel, he actually covered this as well. And so I need to cover this in order to share with you his perspective. And I always want to give credit where it's due. So like the stuff from a legal perspective here, this is absolutely Jeremy Hogan. I'll just provide some thoughts along the way, but I just want to make sure I always give sufficient credit where it is due. I am not some sort of legal genius. I'm just a lay person. I again, like I said at the outset of the video, I do not have a legal background of any kind. So it's really valuable to me to be able to get perspectives from people that are willing to talk about this case. And thankfully, there actually are a number of attorneys that are willing to discuss just that. So here's a little snippet from the Forbes article. Last Friday, the SEC's response to Deaton landed in Rhode Island. For those watching the Ripple case in New York, it carried an astonishing argument. The SEC asked to dismiss Deaton's petition because no determination has yet been made on whether XRP is a security. Put two and two together, and the SEC is saying that Ripple and its two top executives had to have reasonable knowledge of something 7 years ago that the agency itself wasn't sure about last Friday. One wonders which part of the 1933 Securities Act the SEC will eventually use to argue that Ripple is obliged to have psychic powers to operate lawfully in the United States. That is like the most powerful freaking line. I love that. I love that so much. And so attorney Jeremy Hogan, he went on and said that the SEC dropped the ball by arguing that point. He says they would have been better off just ignoring this point, even though it's accurate, it's legally accurate, but it's not good for their SEC versus Ripple case, actually. And so he believes that the judge will allow Deaton and XRP holders to intervene in this case. And here's why. He pulled up this. Jeremy Hogan, I think he pulled it from a different website, but I just Googled this and I found the same information from Cornell Law School. And he cited this Rule 24 intervention. And this specifically right here, what I'm highlighting, this is why he thinks that the judge actually will allow intervention here, which would absolutely be fantastic for a number of reasons I'm going to cite right after this. But check this out. And so here's what Rule 24 intervention says, little subsection A2. Claims and interest relating to the property or transaction that is subject of the action and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interest, unless existing parties adequately represent that interest. And so if it qualifies there, then indeed there could be an intervention here. And Jeremy Hogan's personal position on this is that this does qualify, and we will see in all likelihood an actual intervention here. And so he believes that's what's ultimately going to happen, and he thinks that XRP holders absolutely fall under this test. And so if XRP ends up being declared a security, that directly impacts XRP holders. Even if only because exchanges won't allow the trading of it. And so given that's really pretty well an undeniable fact, that should satisfy the section A2 right here. And there should be an intervention allowed by the judge. And so the SEC will fight this, of course, but there's good reason. And Jeremy Hogan cited 3 reasons. that this is not going to be good for the SEC should it go the way that he thinks it ultimately will. With the first being, the judge needs to understand this suit. It's not only about big companies and CEOs, but it's also about XRP holders, some of which have literally put their life savings into XRP. And so you need to add some humanity to this, effectively, is the idea that he was getting across here. You know, put a face to all of this. Understand that it's much more complex than the SEC is trying to make it. Just this idea that Ripple did something wrong, therefore XRP equals security. No. There's so much more to it. And number two, this gets in front of the judge all of the use cases of XRP that have nothing to do with Ripple, which the judge should find very compelling, frankly. And John Deaton, he actually has compiled an extensive list with the help of the XRP community. And I've highlighted that on this channel, and I didn't go share all of the specific examples of how XRP has utility outside of being positioned by Ripple as a bridge currency, but I highlighted that John Deaton was compiling that list so that any of you listening could have gone, and if you had something you wanted to add, because again, he's taking it to court. Like that's what he's doing with this. And so just to see, for the judge to see, because she'll be forced to see this effectively, you know, if there's an intervention here, she will see that XRP, the asset itself, does all this other stuff outside of anything having to do with Ripple. And so how could something logically that has all this additional utility ever be considered to be a security, like the asset itself? You know, even if you can just successfully argue that Ripple sold XRP in a way that you'd sell an investment contract, fine, and that's an if. But it doesn't mean that XRP itself is a security. Just like in the Howey case, which was about orange groves, you know, it was found that all four prongs of the Howey test were satisfied in that I think it was 1946 case. And even so, that didn't mean that oranges suddenly became securities. Of course not. That would be stupid. You'd have to be an idiot stick to think that makes some sort of logical sense. And so, compare that to what we've got going on today. Even if Ripple did something wrong, they made a boo-boo, if they did, it doesn't mean XRP is a freaking security. Can we just use some logic here? Come on. And then third, this forces the judge to make a distinction of all of the ways that people may acquire XRP. It could be from an exchange, it could be from a friend, it could be a gift. Jeremy notes something that John Deaton has long pointed out, actually, which is that there are many holders out there who have XRP and don't have any idea that Ripple exists. And Jeremy Hogan says that matters. You know, how can you be looking to have a company increase the price of XRP when you don't even know the company exists? Think about that. Because the argument here is, was XRP sold as an investment contract? Well, if the XRP that you hold is an investment contract with Ripple, how can that be the case if you don't know that Ripple exists? Does the logic follow? Come on. It's pretty obvious, right? And so clearly it cannot be an investment contract under that particular type of situation here. And so it was all awesome points. And so those were Jeremy Hogan's own original thoughts on that. But here's attorney Kevin Homiak. And again, I'm going to share with you his perspective here. And it was interesting seeing there were a handful of XRP holders that were offended by this. And I don't see how I don't see how you can come to that. It seems to me, look, no offense to anybody out there if you're one of these people, but like, come on. Just because somebody says something that's not necessarily good wouldn't be good if he's right for the progression of the SEC versus Ripple case. If he's just sharing his honest opinion and he's not being a troll, why are you saying that he's being like unhelpful? Like, why are you saying that he's effectively being counterproductive? All these things, there are all sorts of comments along these lines, and it was only from a handful of people. And so, but I read through this and I was thankful that this individual is just sharing his honest opinion. Whether he's right or wrong, we're going to find out. But I like diversity of thought so that I can come to my own informed decision. And if I can only get one side of a story, what the hell good is that? Can we just get both sides and then make our own informed decision? Like, I feel like that's the right way to approach any topic in life. If what you want to do is believe in life as many true things as possible. But if you just want to believe whatever gives you the happy feels, then okay, yeah, don't read anything that's bad. Stick your head in the sand. I'm not going to do that though. And so I'm going to present good and bad sides of arguments on the Moon Lambo channel. That's just how we're going to roll here. And so he went through in great detail explaining what John Deaton was doing in terms of attempting to intervene. And then I got to the part where he was sharing his own original perspective on this. And he wrote, I'm skeptical of the XRP holders' chances. Oh, sorry, guys. I might take a sip of water. Tell you, sometimes just yapping too much, it just dries out the throat a little bit. All right, I'm good though. So he wrote the following: I'm skeptical of the XRP holders' chances to make it anywhere. Whoa, that's not rude. Anywhere in the action. I don't know what the hell that was. Anywhere in the action for a few reasons. First, they didn't include a proposed third-party complaint, so we have no idea what their claims are or who they plan to sue. The SEC? Ripple? Both? This is especially problematic because the deadline for adding new parties is Tuesday. And so again, Jeremy Hogan and John Deaton, they both didn't seem to think that's a problem. Again, to me, there's no way I would ever know, not having a legal background, but Kevin does think it's a problem. And it's worth noting too. Obviously, he did make it clear in a letter to the judge that he is suing the SEC. But again, that's a class action lawsuit that's separate from this, because we're talking here specifically about an intervention. And so Kevin thinks that there should have been some additional information filed here, which apparently wasn't, assuming he's correct here. And then Kevin wrote, second, I think they'll have a tough time showing that the SEC caused their injuries rather than the exchange's decision to delist XRP. Yeah, and so that's one of those things. I was talking about that the other day. I was like, okay, maybe it could be the case, and I don't know, but it could be the case from a legal perspective. It's difficult to argue that the SEC caused the harm. Maybe. I'm not saying it is, but I'm saying it could be. But even if so, the logic doesn't follow. Like, if you're just a person of reasonable intelligence, you know that this all happened because of the SEC, right? And still, though, I would think from a legal perspective, it wouldn't be that difficult to prove that this happened because of the SEC filing against Ripple. Because when did the price actually start tanking? Well, you can look at it on a chart. Go to Live CoinWatch. Go to CoinMarketCap. You can see that the moment the filing occurred on the 22nd, the price was like just dropping like a rock. And then it continued, sure, after exchanges like Coinbase announced they were halting the trading of XRP. But what kicked it off? Again, verifiably true, it was the news. It lines up perfectly, right? And so that's not just correlation. There's causation there. That's absolutely. There's no doubt in my mind. And then Kevin wrote the following. Third, even if they get to intervene and they're allowed to name the SEC commissioner as a defendant, likely after the deadline, and they somehow manage to tie the SEC's actions to their injuries, I think they'll have a tough time with the SEC's merits argument on the writ. Far from being a purely ministerial act, a decision to bring an enforcement action goes to the heart of the SEC's discretion as a government agency. It's the same thing as a prosecutor's decision to charge or plead out a case, the exact time when discretion is most crucial. The XRP holders don't cite any case that's ever held otherwise, and I'm unaware of any. I doubt Judge Torres will break with years of binding precedent and find the decision to bring the enforcement action is non-discretionary. So, we'll see whether Judge Torres allows the XRP holders to intervene, and, if so, whether they will rehash the same claims that the SEC easily dismantled in the underlying Rhode Island case. But I'm skeptical that this will dramatically change the trajectory of the case. Yeah, and so as far as dismantling the arguments, I mean, I think that John Deaton's arguments were actually rather powerful, at least at a minimum from a logical perspective. Again, I don't know whether, you know, like, I know I keep saying it like a broken record. I don't have a legal background, so like, you tell me what works in court. I don't know. But from a logical perspective, John Deaton sure as hell had some great points. But again, and Kevin may not be aware of this, John Deaton, for him, it was strategic, and he said that, and even Jeremy Hogan acknowledged that this was a strategic move, and so even if you don't get a win from that, it ultimately made the SEC say some things that they otherwise wouldn't have said that highlights their hypocrisy, and so we'll see. I just appreciate getting some perspective from different attorneys that have different point of views. Like, to me, that's really valuable, and I appreciate it. But there were again a number of people that just weren't having it. So, I mean, okay, guys, why is it so bad to have different opinions? I mean, now look, and I'll say this too: if moving forward, if I see some more stuff from him, if I ever get the idea that he's spouting a point of view that sounds negative, and it's because he's anti-Ripple and anti-XRP, well, okay, then I'll cite that, of course. I just don't have any evidence of it at this point. He did say that he doesn't hold XRP when he was asked. But yeah, I don't have any indication whatsoever that he's being anything other than forthright. So there you go. And so now you've got opinions from 3 different lawyers, and you can decide what the hell you think makes sense, right? But anyway, thank you for stopping by. I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.